So again, I'm Stephanie Frumpkin. I'm the chair of the MCC PTA Special Education Committee. And we host quarterly speakers, and we're very happy to have the Resolution and Compliance Unit here tonight. I think a lot of parents don't necessarily know about your office, so we're very excited to just sort of introduce the compliance unit, introduce the staff that works there. They work very hard, and we're very grateful they're here with us tonight. So we really appreciate it. We have Dr. Mason here, our Associate Superintendent of Special Ed. We have Diana Wiles, who is the Supervisor of Resolution and Compliance Unit. And I will introduce her, and she will introduce some other people. We are recording, so if you do not want to be recorded, you can take yourself off the camera. We will have a Q&A at the end. So again, I'm very excited that Ms. Wiles is here with us tonight, and I'll just tell you a little bit more information about her. Diana Wiles has over 20 years of experience serving in various roles in public education. She began her career as a special educator and IEP chairperson for Prince George's County Public Schools. For the last 4 years, she taught and attended the Catholic University of American Columbus School of Law Evening Division. I'm sorry, she taught and attended, sorry, during that time. After law school and being admitted to the Maryland State Bar Association, she began working as parent counsel throughout the state, advocating for the needs of students with disabilities and ensuring families' due process rights were protected. After 6 years in private practice, she joined the Office of Legal Counsel for Baltimore City Public Schools and subsequently the Office of General Counsel with PG County Public Schools, where she served as associate counsel representing the school system in matters involving special education and Section 504. Diana is currently the supervisor of Resolution and Compliance Unit with Montgomery County Public Schools, where she provides professional development, rights processes, and policies for the Department of Special Education, and assists with responding to parent complaints and finding solutions to ensure students receive a free and appropriate public education. So I thank you again so much for being here and letting us learn about how Resolution and Compliance Unit and what you do to serve our community.
Thank you, Ms. Frumpkin, and thank you for that introduction. Two of my staff members are here with us tonight, and I want to give them an opportunity to introduce themselves. Rachel Maturana is an instructional specialist in our department, and I'll hand it over to her.
Hi, good evening. Nice to be with you all this evening, and I thank you for the opportunity. Rachel Maturana, instructional specialist under Ms. Wiles.
And Amy Smith also is in our office. Amy.
Hi, good evening, everybody. It's nice to be here. I am an instructional specialist in resolution and compliance. I have spent my entire MCPS career in the same office, previously as a paralegal for 10 years and now as an instructional specialist.
Thank you. I see Rachel Tate has joined us. So I do want to introduce my co-chair of the Special Education Committee. So I don't want to say hello, Rachel, but Rachel is amazing and we're very happy.
Hi guys. My name is Rachel Tate and I am Stephanie's co-chair of the Special Education Committee. I have been with my daughter in MCPS's infants and toddlers program. Now she's in one of the special ed preschool programs. And so we've had a great year so far and I'm excited to be here with you guys.
Thanks, Rachel.
Thank you. Good to see you again, Ms. Tate. And so our office has the pleasure of serving under Dr. Mason, our interim associate superintendent, who unfortunately will be continuing her retirement soon. But under her guidance, we are a strong team and exceptional office. I do want to just take a minute to introduce those team members who are not present. We have two other instructional specialists, Michelle Thompson, Shannon Farmer, who is the instructional specialist for 504 complaints and processes. And then we have a paralegal, Maritza Macias, who works with us on state complaints, as well as our administrative support staff, Maria Ramirez Ramos, who just joined us a few months ago and has come into the office and been very supportive in her efforts to help us stay sane. And Ms. Bloom, Maria Lydia Bloom, who is the administrative secretary. We also have 2 other support staff that are really helping us, Madeline Griffin and Eve Janney. Eve Janney actually joined us to help support the discussions about compensatory recovery services. There has been a lot of help with that work this school year. So I'm going to share my screen. And at the end of this presentation, you will have been introduced to the Resolution and Compliance Unit. We'll provide information on how RACU supports various stakeholders and informed about various ways that our department can assist with dispute resolution. The Resolution and Compliance Unit provides technical support and dispute resolution assistance related to IDEA or Section 504. The office provides various supports and services to multiple stakeholders, including parents, school-based staff, central office staff, and then we also work closely with Maryland State Department of Education, supporting the process to for supporting the dispute resolution process and to ensure that the district is in compliance. Our goal is to be collaborative. That is a core principle in the work that we do. Without collaboration between the parents, the school staff, our central office staff, our work would not be successful. The goal is for us to ensure the provision of FAPE for students with disabilities through monitoring and providing technical support to our school teams in order to ensure compliance. So some of the major functions of our office, let me just say, it is a big job. It's a big job for all of us. I have the pleasure of working with some very diligent, intelligent, hardworking staff members who are there before I get there in the morning and after I leave to pick my children up. So they do a lot, they cover a lot of bases, they work with a lot of schools. Some of the things that we do on a regular basis is conduct informal dispute resolution by responding to emails, phone calls from parents. So anytime a parent calls our office, they're directed typically to the instructional specialist who is assigned to the area in which their child attends school. We have 3 areas, and Amy, Rachel, and Michelle support different areas. If your child has a Section 504 plan, they're directed to Shannon. If someone is out, then we work collaboratively together. And I also may take some of those calls to help support my staff. We also manage the administrative review process. And I will provide this presentation to Ms. Frumpkin so that you all will have it afterwards. Here is the form that is completed in order to initiate a request for an administrative review. And the administrative review process is a process where internally we take information from the parent to find out what issues may be arising with the school team. And we try to help problem solve so that we can work with both you as the parent and the school to avoid costly litigation, time-consuming mediation, and all of these other things that might come out of disputes. We also respond to and support MSDE state complaint investigations. We participate as school system representatives in mediations and dispute resolution sessions, and we try to find mutually beneficial resolutions for both the parents and the school team. This year, a big part of our work has been responding to compensatory recovery services inquiries. All students in the state of Maryland with IEPs we were required to have, each of the school systems was required to have a discussion about whether or not there was learning loss or regression during the pandemic closures. And we have had over 20,000 of those discussions. And when there is a difference in opinion at the IEP table or in the discussion with the families, those differences come to our office and we try to work with the family to find a resolution. We also provide systemic and targeted professional development to school teams and central office staff. If there are new initiatives that come from MSDE, changes in the law, we'll provide systemic professional development. But we also, if we find that there are schools that are having some challenges with compliance issues, we've supported schools this year that have had vacancies all school year because of the loss of some teachers. We provide that professional development and that support. We help parents to understand their procedural safeguard rights and options when there is a disagreement. And then we also appoint parent surrogates as needed. So when we have children that come into the school system who do not have a parent available to participate in the IEP process, then we work to get someone appointed who is trained in special ed to help support that student. We develop and revise processes and regulations so that we make sure that we are aligned with any changes in law. We're at the end of a legislative session and we are quickly and expeditiously looking at changes in the law so that we can align our internal regulations and our handbooks and all of the other things that inform the work that we do. We attend and provide technical support for disciplinary matters. If there is a need to have a manifestation meeting for a student, which is required if the student has been suspended for 10 days in a school year, my team is at each of those meetings to ensure that the team is acting in compliance and that we are ensuring that students' rights are being upheld. And then we provide support to school teams on problem solving and the IEP process. So oftentimes we may get calls from schools in the middle of IEP meetings where they may be unsure of something that they need to do or of information that they need to provide parents. As you all know, special education is big. It is a giant. And so sometimes things will come up in IEP meetings that school teams just haven't seen before or have not had to deal with regularly. So we stand by, and when we get those calls, we help to talk through some of those novel issues with school teams. So what happens when parents and school teams disagree? In the dispute resolutions, when we're working to resolve disputes, our priorities are to listen to parents, teachers, administrators, central office staff. That is the very first thing. We want to hear from you. We want to be able to identify what the issues are. We work in an open-minded fashion and we are solution oriented. We want to discuss the issues and we want to try to find ways that while oftentimes if there's a dispute, everyone won't get everything that they may want for the student, but we try to meet in the middle, and ultimately we're providing student-oriented guidance and recommendation, because whatever the dispute may be, our goal is to make sure the student is being provided a FAPE. We prioritize accurate, timely, and compliant information to inform parents' decision-making. So we want to ensure that what we're giving you as information is the most current information from the state, from the federal government, and the most accurate. And then we act as neutral problem solvers. So while we are district employees, it is our goal to make sure that we are hearing all sides of an issue and that we're providing neutral problem solving solutions for the team and the parent to consider. So I just wanted to talk a few minutes about the different dispute resolution processes that we have, because generally that is how you will get to resolution and compliance unit. You have a dispute. Now, before I go there, compliance is part of our work. And that's really the work that we do when we are working with the state to make sure that when we're audited, if there are any corrective actions that need to be taken, we're training staff, we are implementing any programmatic changes that need to be made. And so we are doing training very regularly. But the piece where most of our interaction with parents comes in is the resolution. And so the first way that we help with dispute resolution, as I showed you earlier, the form is the administrative review process. And this is an MCPS internal process. It allows us to investigate concerns with matters related to Section 504 or IDEA. So for example, if you have an IEP meeting and you come out and you are dissatisfied with either the decisions, the proposals, the way that the meeting was handled, the recommendations by the school team, you have the option of using the administrative review process. And as I said before, what we do is when we collect that information from you, someone is assigned, Rachel, usually Rachel, Michelle, Amy, or Shannon if it's a 504, and then we will contact you and discuss what your concerns are so that we can gather more information and get clarity on how we can help resolve the issue. In that process, we'll also talk to the school team, we'll review student records, and then we'll come up with a recommendation that we discuss with Dr. Mason prior to sending it to the family. And, you know, like any other situation, when you're dealing with dispute resolution, we don't always propose the exact remedy that the parent may desire, but we do try to give you as an option what would provide the student faith and what would be in line with compliance and with IDEA. The second way that you can initiate a dispute resolution process is through an MSDE state complaint. And so we don't do intake for those. There is a process and a document that's filed with the state of Maryland. MCPS works with MSDE very closely when those complaints come in. Marissa Macias is our paralegal, and she receives those complaints. That process, it starts with MSDE. We're notified of the complaint, and then we work with them to gather information, to do interviews with school staff if necessary. And again, if we know that there has been some violation of IDEA, we try to work with the MSDE to resolve that matter. It's not our goal to fight, for lack of a better word, with the state or with the parent. If we know that we have a school team that got it wrong, then we want to ensure that there's a proper remedy. The next way of dispute resolution is mediation, and mediation is filed with the Office of Administrative Hearings, which also has a document and a process. The form is filed with the Office of Administrative Hearings, and then we also receive a copy. Mediation is a process that is voluntary. It requires consent with both MCPS and the parent or guardian, and the goal is to reach a mutually agreeable resolution to a disagreement related to IDEA. The mediators are usually staff attorneys or administrative law judges, and they work in the role of a mediator. If you've ever participated in a mediation, then one of the goals for the mediator is to be and to remain neutral. And they're really just there to help facilitate the discussion between the parent and the school system. They may offer some suggestions based on the discussions, but ultimately the goal is to have the parties, the parent and the school system, reach an agreement. The due process complaint is the process by which it's also filed with the Office of Administrative Hearings, and it involves litigating a disputed matter before an administrative law judge. And in this case, the judge, similar to if you've been to court for anything, it is similar to a court proceeding where you call witnesses, you have evidence, and then based on the witness testimony, the documents, the judge will issue a binding decision that is binding on both the parent and MCPS. And so to the extent that we can, we try to avoid due process because for several reasons. One is time consuming for both parents and for the school system. Oftentimes teachers, related service providers have to be pulled out of school, and it affects their abilities to do the work that we all love to do, which is work with our students. But secondly, we try to avoid due process cases because we want to work with parents. And at the point at which it becomes a due process complaint and it is in litigation, it becomes an adversarial process. And so resolution and compliance unit, our goal is to the extent that we can, is to avoid the adversary nature of due process. So to the extent that we can, we will try to avoid it. The other process that we encourage families to use is the facilitated IEP meeting process. This is also a process where there's a mediator who is, and forgive me, I cannot remember the name of the agency that we use, but it's a community agency that we use where we contact them, either my office or we will work with the school team to contact the office, and they will assign a neutral mediator to work with the school team. They will actually attend the IEP meeting so that they are able to help move along a process. And this usually works well if you have a team and a school team and parents representatives who are present, and some of the communication has broken down between everyone. And so the facilitator is there to help to move along that discussion and hopefully build back some of that rapport and that trust so that the school team can work with the parent again. Because ultimately, you need to have a good relationship with your school team, because those are the folks that see your children every day. They're the ones that work with your children every day. And so we want to ensure that there is a level of trust in the fact that they are doing everything to meet your child's needs.
It's the Conflict Resolution Center of Montgomery County, correct?
Yes, thank you so much. Thank you.
Put it in the chat.
So I've listed all of the folks that are in our office and their titles, as well as the phone number to our office and the general email. If you have any questions, if you have a question specifically about your child, we would ask that if you do email us, you give us enough information, identify your child and the school that they attend so that the request for assistance can be routed to the correct person.
Dinah, I know that you've been providing tremendous information tonight, and there are a couple of questions in the chat from one of our wonderful participants some excellent questions, actually. So I didn't know if this was a good time to take a look at that and try to respond
Yes.
to some of those. Is that okay, Ms.
Sure.
Absolutely.
Faulkner?
Absolutely. Would you, I mean, I'm happy to read the questions unless you want to. Okay. Yeah, thank you. Thank you so much, Ms. Wiles. That was really informative. As I said, I think a lot of people are not so familiar with what you do. You do a lot of important work. And I think it's really helpful to know, like, especially what do you do if you're not agreeing with your team? What if there's a problem? What, parents, like, they don't know what to do. And in this role as the special education committee chair, I get a lot of questions, and parents are very, like, a lot of times they're upset because they don't know what they can do. So I think it's really, really valuable to learn about your office and what all of you do there. And you gave a lot of good information regarding, you should definitely reach out to the resolution compliance unit, but you also gave a good overview of some different ways of dispute resolution. So I think that's really, really helpful and valuable. So thank you. So I will take a look at the chat. Yeah, feel free to put questions. I know some people are holding their questions to the end. So once some people, maybe you can feel free to put in a question.
And that's actually all of the presentation. I just wanted to give you an overview. So any questions, we can move on to questions.
Sure. Rachel, any chance you want to take over the question? Rachel Tate, are you still?
Yeah, hey guys.
You're really good at questions during the Q&A.
Yeah, I can go
Better
ahead
than
and
I am.
do it.
Thank you.
So one of our parents has asked, which is a question for the guest, which he didn't specify which one, but it says, is there a difference between a grievance based on legal or FAPE rights doctrine versus a disagreement based on varying perspectives on educational or psychological philosophy, as in competing PhDs, and at what age can the student chime in?
Sounds like a multi-part question there.
Yeah, I think I
Break
need
that
to
down.
look at that question.
Yeah, hold on. So it says, is there a difference between a grievance based on legal or FAPE right doctrines versus a disagreement based on varying perspectives? Michael, if you're on here, do you want to go ahead and explain this question? Yes.
Michael and I were chatting during, and Michael prefers that the questions are read. And so I think just to help maybe Diana, if I would just look at the first segment of that, is there a difference between legal or FAPE rights? Because actually FAPE rights are legal rights.
Right.
If you could maybe speak to that.
And for anyone
Right.
just not familiar, because we have different range of knowledge about all of this. So
Sure, I will
FAPE mean,
definitely.
go ahead. Thank you.
So FAPE is the cornerstone of what IDEA, the Individuals with Disabilities Education Act is. It is the right of students with disabilities to have a free, appropriate public education. FAPE is what goes into the IEP and how it's implemented. And so when there is a dispute, the legal dispute is whether or not the school system has offered and provided a free, appropriate public education to students. I can kind of venture to answer the second part of that question as it relates to different perspectives on educating and philosophies of educating students. That's not really what our office handles. We don't really get into how we educate students or what curriculum we use for students. What we do is ensure that the provisions of the law are met in the student's IEP, and that those provisions are appropriate for the student and that they are actually implemented in the school setting.
And Diana, wouldn't you say, however, that the law requires the school system, because we're responsible for the provision of FAPE, the decisions about the use of interventions or the curricular resources, that is the law, that's the prerogative of the school district where a student is enrolled. So it isn't a perspective, but rather the use of professionals within the school system who make decisions about the appropriate instructional resources, curriculum development activities that are supposed to be beneficial. I think the other thing that has helped us a great deal over the years in education has been that we've entered an era in the past 20 years where we've shifted from research-based interventions to evidence-based interventions versus the way it was when I began my career, where we didn't have access to those kind of evidence-based practices. So we have an expectation to do that. And then, of course, that question, Diana, about when is it appropriate for the student to chime in or be a part of the IEP process? Could you state that and clarify the difference between Maryland and the federal regulations?
Sure. It's at the age of 14 in the state of Maryland, students have rights. Those rights are that they are able to participate in the IEP process through the transition planning. Transition planning is where we do interviews with our students who will turn 14 in that school year. They provide information as well as the parent on what the students' long-term goals are as they transition through high school, into the work world, into college, or into whatever their post-secondary goals are. The federal law is age 16. So in other words, Maryland in its infinite wisdom has said that we need to start transition planning for our students earlier. And that has been for quite some time now. And so our students who are in middle school begin to start thinking about what they want to do as they start to transition into high school and out of high school into the workforce and the college so that they can be prepared.
And then there are just a couple other quick questions, and then we want to make sure, Ms. Frumpkin, we move on to your other person here. But this is a question about the credentials of people in your office. That's all. What's required? What does it be required? That was Michael's other question.
Okay. And so the people who are in the resolution and compliance unit are, most of my staff has been in a school, has experienced teaching in special education. They are degreed. They are have had extensive training on special education law. They're certificated, and those who are not certificated are in the legal realm. They have training as paralegals. So I have a highly qualified staff that has personally supported children in the school setting, has personally worked within the field of law, and are able to identify what the legal requirements are under IDEA.
Thank you. There's a question here I will read. In addition to compensatory services stemming from remote learning difficulties for kids with special needs, is there also any compensatory services for students who have had aversion post-remote learning? And I will say I've heard a lot about recently about from students, families who they're, from the pandemic, they've gone downhill in certain areas, mental health, that kind of thing. And sometimes they just can't reintegrate. Unfortunately, I've heard a lot of stories like this. So I think that's a very important question.
Yeah, it's a great question. And so let me just kind of back up and explain what compensatory services are generally. Compensatory services are services that make the student whole if they have missed services, regressed, or there has been some violation of IDEA by the school system that has negatively impacted the student. Compensatory recovery services are services that the term was coined by the state to reflect the period of time that all of our students had, were challenged with this new form of being educated virtually during the pandemic shutdowns. So compensatory services have been around for a long time. It is not explicitly stated that way in the law. It developed through cases. We are fortunate to be right beside DC that has had a tremendous amount of case law come out of it regarding compensatory services. For students, though, that have had difficulties reintegrating after the pandemic as they've returned to school, there's a couple things that teams need to consider. If the student is not making progress, or if the student, for example, has some new diagnosis or suspected diagnosis that they didn't have. For example, if you have a child that didn't have anxiety before the pandemic, but because of all of the things that we've all had to go through over the last couple of years, they've developed some anxiety. The first thing that the school team needs to do is reconvene an IEP meeting and talk about whether or not the student needs additional assessments, whether or not the student needs some additional supports and services in the IEP. That would be the first step. And then you would, with those changes in the IEP, you would monitor whether or not those changes are successful for that student. And if they are not, the IEP team should be reconvening at least quarterly when you get your IEP progress reports. So if a student is not making progress on those IEP goals, on those revisions to the IEP, then the IEP team should be coming back, discussing, do we need to make changes, revisions? At times, unfortunately, and I would venture to say, because of the challenges that we have had with vacancies, there may be times that unfortunately school teams, and despite the hard work that they do, they may have missed a meeting with a student that had some challenges. And so compensatory service discussions might come up if, for example, the school team didn't have an opportunity to discuss the fact that the student has not been making progress since school restarted.
Thank you. I think that's really helpful to understand that. I have a question here. It says, how much training do mediators receive in special education? And then I think it's also a two-part question. What constitutes a measurable IEP goal, and what is required by law? So I think that's two different parts. I guess I think the first question was about mediators, like when you go to mediation.
So there is a requirement, and actually, I don't quite remember. I started this process to become a mediator probably 10 or so years ago, and I didn't finish because life happened. But the first requirement is a 40-hour course where you take to learn processes in mediation, how to remain neutral, how to facilitate discussions, all of the nuts and bolts of what mediators do. And then there's a second session that also might be, it's either 20 or 40 hours, I can't remember, but that would be the actual practice that you would be working with a mediator to gain the experience. And then when you finish that, you would become a mediator that could actually do mediation in a legal setting. And so that would be what I'm sure in the Office of Administrative Hearings, the training that they have to go through. I don't know if the facilitators are also going through that training because they're considered facilitators and not mediators. But I do know that the mediators who are working in any kind of legal realm have to be provided that training.
Thank you. And I guess it's part two is different, but what constitutes a measurable IEP goal and what is required by law? It's a little bit outside of our topic tonight, but I don't know if you want to go into that.
So part of that, I'm going to turn to my wonderful colleague, Phil, to talk about what measurable goal is. But what I will say is that the law does not specify how a goal should be. IDEA is not specific on how a goal should be written. So MSDE really does provide that guidance to school systems. And there has been some guidance that we've been providing to our teams. And so I'll let Phil speak to that.
Yeah, thank you for being here, Mr. Lynch, the Director of Special Education Services. Thank you.
Spreading the wealth. So in terms of the way the goals are written, we're required to write goals that are written towards the curriculum standards. There are goals that can be written for students to be working, as Dr. Mason mentioned, on those research-based interventions, in which case it may reflect a goal that would be a student working towards a below grade level standard. But those standards need to be reflected in the goals. And then we also in the goal need to reflect the way in which we're going to support the student to achieve that goal. And then the most important piece to your question is really that there needs to be a criteria for what that progress is going to look like. So you may have students working on very similar goals, but the criteria based on the rate of progress that the student is expected to make over the time that that IEP is going to be in place, that may differ for students based on the impact of their disability. So it's a difficult question to answer because there's no one answer. It's going to depend on the rate of progress that the student is expected to make based on how impacted they are in that area. So there are some students who may work towards at a faster rate of progress on any given goal, and some students for whom that rate of progress is going to look it may be a slower rate of progress on that goal. And so there's no one answer to that question. It really has to be looked at through the lens of the student and their disability. And so that's really, when we develop and draft those IEPs, it's important for everybody to take into account where the student's currently performing, but also that trend data, how has the student performed over the last several years? So you have a sense of their rate of progress, and you can, write that goal to be relevant or meaningful. And we are really working, hard this year and moving forward to train our teachers to make sure that they're writing goals that are measurable and where they can identify those, those artifacts that are going to be used, to measure that progress and to share with parents in a more meaningful way. If you, there's a whole different conversation you can have about what meaningful progress looks like, through the most recent case law, NDREF and all that. That's a whole different conversation. But we are required to make to write goals where students can make that meaningful progress. But meaningful progress, again, may look different for each student.
Thank you so much. I'm going to go with Melanie and Scott, who patiently had their hand raised for a long time. So just if you could just please make it not specific about your own child, that would be helpful. Thank you.
Okay, we'll try to generalize it.
Thank you.
Obviously, it's based on our specific case, but one of the things that occurs to me as you were doing your presentation is you must have a tremendous amount of work to do, and you don't seem to have that much in the way of staff. So I am completely sympathetic with the work that you do. But what is if a parent makes a request, an informal request, because the school has denied compensatory services, what kind of turnaround time can be expected? And I will put all my cards on the table. We called you guys back at the end of February, and we have yet to hear a response. And again, I'm sympathetic, but I just don't want you to think I'm asking you a leading question here. But when can we expect a response generally, or when can a parent expect a response?
Okay, first, let me say that for any delay that you've experienced, I apologize. I would encourage you to send me an email and ask you to, well, actually, if you send it to the RACU at MCPS, one of the secretaries will get it and they'll forward it to me. The turnaround time depends on what process you use. Office of Administrative Hearings has statutory requirements in terms of when things are scheduled and when mediations have to occur, when hearings have to occur. For our internal purposes with an administrative review, I'm going to say, forgive me, I've been here since October, haven't dealt with many administrative reviews. So I'm gonna ask Amy to make sure that I'm not telling a lie. I believe it's 20 days is our turnaround time.
20 calendar days, that's correct.
20 calendar days. So we make every effort to try to turn around an administrative review within 20 days of the date that we receive it from the family. What I will say is, you know, if you send an email or there's a phone call, it may behoove you to just do the administrative review and document it so that, you know, we start that clock ticking, because sometimes what happens is we will get a phone call, a quick question, and we'll think that we have answered it and resolved it. The other way that things may come to us is that if there was a disagreement with the school team, and sometimes families may think that the school team has reached out to us, and then the school team will think that the parent reached out to us. So I would just encourage you to contact us directly, and not, you know, make the assumption that the school team, because you've voiced that there is a dispute or disagreement, has reached out to us on your behalf.
Thank you.
Okay.
Okay, thank you.
Thanks a lot. That's a good question. What kinds of strategies do you recommend parents use to foster and continue a good relationship? I guess it was in quotes, but I think you used that in your presentation. A good relationship with their child's school team. Which have you seen work best over the years? I like that question. It's interesting.
I like that question too. I don't know that I can fully answer it other than to say, I think everyone should come into a meeting or even a discussion about a student open-minded and empathetic. This year has been challenging for everyone. It has been extremely challenging for everyone. And, you know, part of the work that I always try to encourage people on a school level and parents and let them know that I understand. And I do. I have children of my own. I was one that was sitting here with both my children right beside me during the pandemic, and I know what the challenges were. But I think that that's really the most important thing, is be open-minded and be empathetic, for the parents to understand, you know, that my strong belief is that all of our educators, general educators, special educators, are there because they love the work. They love the children and they want to do what's right by students. Likewise, our educators need to understand that these are your children and that they come home to you every night, and after they have gone on to the next grade and into life, that you will continue to support them. And so it has worked for me throughout my career to just make sure that I'm being empathetic towards the folks that I'm working with. And I've been on all sides of the IEP table, so I understand.
Thank you. Good answer. It's important.
Did you want me to go ahead and move on?
Yeah, please.
Okay. Susan asked, we were approved for compensatory services, but never have heard anything about them. When will we start to receive them?
So I would encourage you to send us an email. Tell me what school, if you just tell me the school, then I know who to direct it to.
Yeah, maybe if she could private message.
Yeah, if you can, and then that way.
Well, I don't know. But,
well, they won't. The reason why I say that is because then I can direct it to either Rachel, Amy, or Michelle.
Okay,
and they
maybe how about cluster? What's your what cluster? I think that would be helpful, right? I hate to call out any particular school right now. What high school cluster? You know, what's your high school?
It's the Sherwood High School cluster.
Thank you.
Okay, so if you can, Ms. Ornstein, I hope I'm saying that correctly. Rachel, if you can just put your email in the chat, if you can email Rachel and give her your child's information, and she can follow up with that. The process was for once the school team made the determination about compensatory recovery services, and if you agreed, the school team would determine if they had someone in the building that could provide those services. And if not, they made a referral to Jonathan Langsam, who is at central office, and his job is to help with finding providers depending on what those services are. So what
his
we
name
would
in the
do,
chat. It's Jonathan. What?
Langsam.
Jonathan.
I'll put it in the chat.
Oh, okay. Thank you. And if you have a contact info, I hear this question a lot. Who can reach out to?
Yeah, and so school teams, if they cannot provide the support, then they refer it to Mr. Langsam's office, and he will try to find someone to provide the services.
Yes, we have wonderful staff members, over 400 who are providing services. Some make individual appointments with parents to work out mutually agreeable times. And we even have regional locations on the weekend where services are being provided. So thank you so much, Ms. Orstein, for sharing that concern. And we'll make sure that we'll follow up.
And I can follow up with Lisa, who has some concerns. I will follow up with her.
Thank you.
Thanks, Amy.
I have a question here. What level of consideration does RACU give to outside professional service / therapy providers who have insights into special education deficits that may be present in a child's classroom experience? So I guess outside providers.
Right. Great question. So the first stop for any outside provider report, support, or opinions about a particular student is really the school IEP team. Any information that an outside provider has should be shared with the IEP team. We advise teams to convene an IEP meeting. So if there is additional information, student, for example, is getting speech and language therapy outside of school, and there's a recommendation for either some changes or some increase in the school setting, the IEP team has an obligation to review that information. Parents can invite whomever they deem is appropriate to attend IEP meetings with them. And we encourage them to invite anyone that has information that can help us support students. But the IEP team ultimately will work with the parent and their team of outside providers to determine what's appropriate to be added to the IEP. The one thing that we have to remember with that, though, is that there are times when this can be an area of disagreement. And it's primarily because there's a difference in the law with what is required under IDEA and what a student might need or be receiving outside of school. IDEA, the focus is to provide the services the student needs to access the general education curriculum. It's the accommodations, it's the goals, the specially designed instruction that's provided. But we do know, especially in this time, that students might have other needs that have developed out of the pandemic. They may get counseling services outside of school, and the school team will look at whether or not the need is reflected in what they're doing in the school setting.
Okay, thank you. Like one or two more questions, getting to around 8 o'clock. So someone asked, where can I find a list of IEP resources for students based on their needs and concerns? Is there a link? Like what kind of,
We have a, I'll jump in on that
okay,
one.
sure.
We have a wonderful website, if you haven't checked it out, called it's Hyatt. If you go to our MCPS website and you put in Hyatt, High Incidence Accessible Technology, and there is a portion of that page where you can match students' needs with different tools and resources to support the student. And so there's an aspect of that page. So I would encourage folks to check out that website. It's nationally recognized. When I go to conferences, I hear other folks talk about the resources that we have on that page and how they've accessed it. So take a look at that. That is one place that you can look at for in terms of resources for students.
Yeah, I wasn't sure. Yeah, I mean, there's lots of different websites. I like understood.org. It's a great resource for parents. Parents Place of Maryland is also super helpful if you have questions.
And one of the other leading sources is Rights Law.
Rights Law, yes.
WRIGH.
Yeah, I'll put it in the chat. Rights Law.
That's That's law. Rights Law has been around for a very long time, and they produce books on special ed. They provide training on special ed. It's an excellent resource. It's geared towards parents, but it's actually useful for school systems as well.
It's my favorite book. Promotions to Advocacy. It's a great book. It's like really helpful for parents. I read it twice, so I highly recommend it. It's from Rights Law. So. But I think it's about 8 o'clock, and I know it's late for staff here, so I'm gonna let you go. But we really appreciate you being here and talking to us, and I think it's just really valuable to learn about it and learn about what you do and RACU, and just to introduce yourselves, like who you are, what your faces, your names, and it's really helpful. I just said I think a lot of parents don't know where to turn, so I think your office is a really valuable resource to parents. So thank you so much for being here and informing us about what you do, and I'm sure you're getting some contacts and calls, and we appreciate you just doing this presentation.
You're
welcome. End of
Thank
school
you for
year.
inviting me. Right.
Yeah.
Thank you.
So-
And thank you for inviting us. And we would be more than willing to come back and discuss anything else any issues that you all have that you want to discuss as a group.
Thank you so much. So have a great
Thank you
night,
for
everyone.
everything.
Yeah, thank you. Have a great summer. Not so long off, right? All right, take care.